Hi, sorry about that, guys. I'm back. As I was explaining, this is an order from the judge. Point blank, period. She's stating why she did what she did and the decisions she made as far as motions that were put in limine, pre-trial, and during the trial. Okay? Now, it says, Ann Donnelly, the United States District Judge. The defendant was charged with racketeering in violation of 18 U.S.C. 1962C. 1962 was a law that was made in 1962. Section C, part of the violation Title 18, the United States Codes. And for 1963. 3 counts of Mann Act, transportation, to engage in illegal sexual activity in violation of the 18 U.S.C. 24121A. Okay? 3 counts of it. Listen, buddy, I'm on a live, and Joshua will be with you guys when I'm done.
Okay.
All right, okay. Thank you. Sorry about that. So, 3 counts of Mann Act, transportation, and 3 counts of Mann Act, coercion and enticement to engage in illegal sexual activity in violation of 18 U.S. Code 2422A. 1 count of Mann Act, coercion of a minor to engage in illegal sexual activity in violation of 18 U.S.C. 2422B. Okay? Now understand this. It's 3 counts of transportation to engage in illegal sexual activity. In here, they're only speaking of 1 minor, and that's Geronda Pace. She's the only minor that was in here besides the other girl. What was her name? Stephanie, right? Was it Stephanie? No, Addie. No, Stephanie. Stephanie. I believe it was the girl Stephanie. Jane Doe number 2. She was the other minor. But there was no it was for the coercion of a minor to engage. Right, 1 count of Mann Act, coercion of a minor to engage in illegal sexual activity in violation of 18 U.S.C. 2422B, and 1 count of Mann Act, transportation of a minor with intent to engage in illegal sexual activity. So the only 2 minors, the 1 count was for Stephanie, the other count was for Geronda Pace. The other 3 accounts were for Faith, and the other 3 accounts were for La Otra Loca, Azriel. Okay, let's get that together. And on September 27th, now see these ECF number 43. These are the documents that were put in. So it's document number 43. So if you have Pacer, you can go through the documents. And you would go through it, and it should say number 43. Okay? Now, it says that on September 27th of 2021, the jury convicted the defendant of all counts. Then here it says TR 4765-73. So this is the T stands for trial. The TR stands for transcripts. So if you go back and you want to research, you go back to the transcript, pages 4765 all the way to 4773, you will understand what she's talking about. Right? Okay. Good. Let's just get that out of the way as well. Prior to trial, the government filed motions in limine, which the defendant generally opposed. So now she's explaining the documents that were put in as motions in limine, that the government made and filed these motions, and the defendant, denied he opposed the motions. He fought on them. Okay? He denied them in a sense, right? And their numbers 121, 133, 136, 137, 145, 146, 141. Those are the documents. If you go back into Pacer, you can see those motions and what was done, what was said, right? Then it says that at the final pretrial conference on August 3rd of 2021, and before opening arguments on August 18th, 2021, I ruled on most of these requests, okay, reserving decisions on 2 of them. Now, when she talks about she ruled on most of these requests and she was reserving her decision on 2 of them. Okay? So these are the motions that she was talking about up on top that she ruled on, and 2 of the decisions she reserved her decision on 2 of those. And here it says a number 1 right next to the word them, right? Now that goes to the subparagraph that's right here underneath. See, so there's a 1 here. This 1 goes to this paragraph here to explain this whole sentence. Okay? It explains this whole sentence. Okay? Now, these here are the documents. I can't write right, but I'm going to try my best, okay? Those are the docs. Now, in this part here, she says that the rule 404B and 3, okay, there's a rule 404 of the criminal federal codes, right? And it's part of sections B and 3. And it says in that part that it requires the government to provide reasonable notice of any rule 404B evidence before trial, so that the defendant has a fair opportunity to meet it. Now, the written notice must articulate the permitted purpose for which the government intends to offer the evidence and the reasoning that supports the purpose. So they have to put in a notice that articulates the purpose for which the government intended to offer the evidence, right? And that's what motions in limine are. Talking about things that want to be in evidence or taken out of evidence, things like that. And it would be, you guys, I don't know, you guys, a lot of you guys pay attention to Angie, right? She's spoken about the types of evidence, circumstantial, what is it? Circumstantial and cumulative evidence, right? And so, you got the stuff that's backed up with tangible evidence, and then also testimonies as evidence. So those things are evidence, testimonies, as well as tangible items, papers, paperwork, videos, pictures, things of that nature, articles of clothing, stuff like that. So now on July 23rd of 2021, the government filed its motion in limine outlining evidence it sought to admit at trial, including under the Rule 404B, and for each request. So the permitted purpose for the evidence and the corresponding reason. Okay? So on July 23rd, the government put in a motion in limine outlining what they were going to put into evidence that falls under the Rule 404B, and for each request, the permitted purpose for the evidence and also the corresponding reasoning. So the evidence that they were submitting, as well as the reasons why they were submitting the evidence. And then it talks about that in number 133 and 135. And like I said up here at the top, she highlights these are the documents that she made decisions on. Okay? And when we're talking about this here with the government's Rule to 404, it's in documents 133 and 135. Okay? And thank you for the super chat. Now, it continues to say that thus the government, all right, now, there's going to be another part to this, and it'll probably be on the bottom here. Right. So this is the other part to that. All right. But we'll get back to that in a second. Okay. So now in the end here, in her last sentence, where she's gonna, where she starts a new sentence, shall I say, here she talks about HRG. I don't know what's that, but I do know that this is the trial. I guess it's page 35. And then it's page 35, sentences 7 to 36. And then something at 11. Also trial transcripts, paragraphs 4 through 8, or pages 4 through 8, one or the other. Now, it states that in this trial transcripts pages, it states that on September 27th of 2021, the jury, so that must have been the verdict pages, the jury verdict pages probably, right? Now the jury delivered its verdict, finding the defendant guilty of each of the 9 counts charged. And then it talks about the transcript 4765 through 4773. These are the pages. Now she says that this opinion, now you see, this is her opinion, okay? She explains it here. This opinion explains the rationale for those rulings. And then again, she says, subparagraph number 2, which we know was to be all the way at the bottom. Whoa, whoa, whoa. Right here. Okay? So she'll explain herself in there. Okay? Now, legal standard. Now, it's going to explain the purpose of an in limine motion. She says that the purpose of an in limine motion is to aid the trial process by enabling the court to rule in advance of trial on the relevance of certain forecasted evidence. Like I said, basically it's to go back and forth, to take away evidence, add evidence, take away evidence, add evidence. Okay? And also to explain what kind of evidence they're going to put in, and also explaining why they want this evidence taken away or why they want this evidence submitted. So, as to issues that are definitely set for trial without lengthy argument at or interruption of trial. All right. So in other words, they go through all of these legal battles back and forth so that the trial isn't so long. So they do all these pre-trial motions. In other words, they're fighting before the actual trial even happens. Okay. Now, McLeod versus Wano, I'm not too sure how you pronounce that. Then it's okay, so it talks about a case law. And that it says that the Eastern District of New York, April 28th of 2021. All right. Now it's quoting that this case law, and then it says that in this case law that in limine rulings are subject to change. They're subject to change when the case unfolds. And then it talks about another case law, something that happened in 1984. And it states that under the federal rules of evidence, evidence is admissible only if it is relevant. And then it says about the federal rule of evidence 402. It states that in the 402, it talks about how evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. So the evidence is more relevant and it can be admissible as long as it's relevant and it has tendency to make facts on top of facts or less probable than it would be without any evidence. So we got to have facts on top of facts. And the fact is of consequence in determining the action. So whatever the facts are, the consequences behind that, whatever the facts are, it will depend what the consequences are behind that action. And then it says that it's also federal 401 under the rule 403. It says that evidence that is relevant may nevertheless be excluded if it is probative. If its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needless presenting cumulative evidence. So I believe cumulative evidence, I believe it was hearsay evidence. I'm not sure. I got to remember again. So in other words, under the 403, evidence that is relevant may nevertheless be excluded. So it can be excluded if its probative value is substantially outweighed by a danger of one or more of the following. So it could be excluded if the judge feels that it's unfair or prejudice, or that it's confusing, that it's misleading the jury to where they don't need to go, undue delay, like it's just like that's just not happening, wasting our time, or needless presenting cumulative evidence. I forgot what cumulative evidence is, damn it. Do you guys remember what cumulative evidence is? I believe it's hearsay. I don't remember. But let me see. Let me hold up. Oh, okay. So wait. All right, here we go. All right, so cumulative evidence is facts or information that proves what has previously been established by other information concerning the same issues. So another equates cumulative evidence with corroborative evidence. Okay, got it. So fact evidence has to go with corroborating evidence to make it fact on top of fact. So, but the term cumulative evidence more commonly and more properly means unnecessary evidence proffered to prove what is already adequately established. So in other words, they're like, we're showing facts, but you're throwing more facts on top of those facts. It's just cumulative evidence. It was already established. Like, you didn't even need to add more evidence on top of that evidence because It was already seen and proven. Profer to prove. Right? Then it says that Fed Rule Evidence 403, in applying 403, the court conscientiously balances the proffered evidence's probative value with the risk of the enumerated dangers. So let's see, what's enumerated dangers? Powers Act offers an ideal opportunity to put every no. Did I read it right? Let me go back. Oh shit. Hold on 1 second. My mom's calling me. Give me a second, guys. So that means enumerated dangers means crimes of violence. Okay. Sorry about that, guys. I still got activity going on. This is why I like to do things late at night. You know, everybody's asleep. I can focus. Okay. So, and next, then it talks about another state law, a case that happened in 2006 in the Second Circuit courts. Now, remember what I said earlier about the note here that it said number 2. So in this part, in number 2, it says it explains the rationale for the rulings that she made, right? And it says that, what was the last, on September? Okay. The rulings, right? That was part 1. Hold on. Okay. Now, it continued to say that in documents number 133 and 135, that thus the government met to Thus, the government met the notice requirement of Rule 404B. And then it says, see Federal Rule Evidence 404B, Advisory Committee's Note to 2020 Amendment. In many cases, notice is provided when the government moves in limine for an advance ruling on the admissibility of Rule 404B evidence. Thank you, baby. You brought down 2 for her?
Yeah.
Okay,
No, I'm
3?
bringing down another one.
Oh, okay, cool. Okay. Thank you, honey. Catch your breath. He's such a good boy. Then it says, nevertheless, based on the defendant's representation at the final pretrial conference, it says that nevertheless, based on the defendant's representation at the final pretrial conference, that he needed more time to respond to certain requests. Now, the court reserved decision on those requests and directed the parties to submit supplemental briefings, notably, and as explained below, almost all the evidence the government sought to admit was relevant to proving the enterprise and its structure, rather than other acts' evidence. Okay. Then it says that the government moved to admit some evidence that it did not ultimately offer. Now, accordingly, I do not discuss those rulings. She does not discuss those rulings. Okay. So the government moved to admit some evidence that it did not ultimately offer. So in other words, the government put in stuff that the government moved to admit some evidence that it did not ultimately offer. So in other words, the government offered something, but they didn't offer it. They moved to admit some of the evidence. Okay? So they took out some evidence that they didn't even put it in, but they took out evidence. They moved it. They moved to admit some evidence. I hope you guys get that. You know, this legal talk, it's a lot of it is confusing how they put words and you know, certain things that they put together, certain words that they put together. It's a lot of legalese stuff, as Miss Esquire would say. The legalese stuff is kind of like hard to follow, so you got to like break it down. You got to try to, you know. That's what I try to do when I read these things. I try to break it down so I kind of generally understand what's going on. If I have to look up words, I'll look it up. If I have to look up a case law, I'll look up the case law. You know, you do real research so you could understand what you're reading. Nobody's a lawyer. Nobody's a lawyer on YouTube. Except for the real lawyers that we know, right? So now, as a general matter, Evidence of a defendant's prior crimes or bad acts is not admissible to prove propensity. So she said that as a general matter, evidence of a defendant's prior crimes or bad acts is not admissible to prove propensity. What is propensity, right? Let's see.
Propensity.
Okay, so propensity is an inclination or natural tendency to behave in a particular way. So a propensity for violence. So the person has a natural tendency to behave in a certain way, whether it be with violence, right? Or a habit, like that. Okay. So, as she said, prior crimes or bad acts is not admissible to prove his propensity, right? To prove propensity, which is what? To behave a particular way, right? Okay. Just trying to see if y'all paying attention to me over there, because I don't know what's going on in the chat. All right. So now in the federal rule evidence of 4.4, that evidence, however, may be admissible for other purposes. So the bad acts, the defendant's evidence of a defendant's prior crimes or bad acts, which is that evidence, however, may be admissible for other purposes, including to prove motive, which we would say modus of operandi, right? The opportunity was to get all the sex he can and all the girls he can, right? Intent was to control them. The preparation, how he got the girls, when he got the girls. The plan, right? How we're going to do it. This one's going to call this one. This one's going to book that flight. This one's going to book that hotel. The knowledge, he knew everything that was going on because he was the one that was directing everybody who aided and abetted for him, right? The identity, we all know who it is who was on those tapes. We all know who worked with who and who saw who, right? The enablers know the girls know the enablers, the handlers, the runners, right? The managers, right? Absence of mistake. I don't know what that means, but we're going to look that up. Or lack of accident. So, it said what? Absence of mistake. Let's see what they mean by that. Okay. So in the Rule 4.4b states that evidence of other acts are admissible to show that the person had opportunity, intent, knowledge, or absence of mistake. Now, this rule of evidence is often used in criminal trials, but it is criminally underutilized in civil trials. So let me go back. Okay, so absence of mistake or accident, because it also says accident, it expresses two, not one, of the purposes for which evidence of the defendant's bad character and specifically previous crimes that may be admissible. And then it says absence of mistake or accident. Oh, so what it means is and not. In other words, saying non-existence or non-occurrence of a mistake, nor of an accident. So I see you prefer the explanation to be, oh, no, sorry. That was something else. Okay. Okay, wait. Oh, okay. So in other words, that means that a defendant may argue, among other things, that the alleged offense was the result of a mistake or an accident. So example, if he didn't realize that the white powder was cocaine, or an accident, example of an accident would be the gun went off by accident. So if the prosecution can show that the defendant was experienced in the use of the firearms or the drugs, then these defenses are less likely to be successful. So it's not impossible in theory that the defendant may argue both mistake and accident. And if so, the prosecution must rebut them separately. And it must show both absence of mistake and absence of accident. But normally, it will be one or the other. And so, absence of mistake or accident. And means that the prosecution may introduce evidence of previous criminal acts to rebut either of these defenses, but not necessarily both. So the word or expresses alternatives, either or, right? Okay. And as we know that it talks about, how that is. So that's what that is, guys. All right. He's trying to say it was a mistake. No, you can't say it was a mistake. What's wrong with you? It wasn't no accident. Yo, pee-pee didn't accidentally run down her face. Okay? Your pee-pee did not accidentally run down her face. Or your fist didn't accidentally slap one of the girls. Or it was a mistake for you to have Azriel smear feces all over herself. These things can happen. It's not a mistake if you did it more than once. Okay. Wepa. Thank you, Darcy. Okay. Okay. Now, Federal R Evidence 404B2 talks about how the Second Circuit, okay, which the Second Circuit, guys, remember the Second Circuit is an appeals court, okay, and that's usually where she might go, Miss, what's her name? Jennifer, what? Bonjon, Jennifer Bonjon, or Bonjon, right? Yeah. Bonjon, let's say it like that. The Second Circuit, okay, is an appeals court. So that's where she's going to go to do this appeal if once it gets granted. Okay? So that's where she would be going, to the Second Circuit courts to go for an appeal. And the Second Circuit, the appeals court, is usually 3 judges. Okay? And they're the ones who will come down with the decision of granting the appeal or not. It's not with a trial or anything like that. It's just 3 judges who sit on a bench, and you have to present an appeal like a book. Let me tell you something. You have to put a table of contents in it, all types of things. I was checking that out, and woo, good Lord. That lawyer got a whole lot of working to do. You know, if she's got to do it, let's see. You know, let's see what she comes up with, guys. Now, the Second Circuit follows the inclusionary approach, which admits all other acts, evidence that does not serve the sole purpose of showing the defendant's bad character, and that is neither overly prejudicial nor relevant. So the Second Circuit follows the inclusionary approach. Okay? So let's see. Inclusionary. Joshua, what are you doing, baby? What was the word again? What was it again? Inclusionary approach, right? Inclusionary approach. All right, so okay, so inclusionary approach rule. Okay, so an inclusionary approach rule is a legal principle admitting evidence of a prior crime or act. Under this rule, evidence is admitted in order to show a defendant's criminal propensity as long as it is relevant to some disputed issue. Inclusionary approach rule states that the probative value of evidence outweighs its prejudicial effect. So, okay, doesn't matter. It overweighs that. Okay. And then it talks about a case law and the summary order of that case law. And it also quotes another case law in this sentence saying that, moreover, Rule 404B does not preclude direct evidence of the existence of a RICO enterprise. Now, evidence that is inextricably intertwined with evidence of a charged offense or evidence that provides necessary background to the charged offenses. So direct evidence, so it does not preclude. Let's see, what's preclude? What is preclude, guys? What is preclude, right?
Preclude.
It's to prevent from happening or make impossible. So it does not preclude direct evidence of the existence of a RICO enterprise. So it says that, moreover, the Rule 404B, it says that it prevents from happening or makes impossible, right? So it does not make it happen or make it impossible by direct evidence of the existence of a RICO enterprise. So evidence that is inextricably intertwined. So the corroborative and the bad act charges go together. They intertwine with evidence of a charged offense or evidence that provides necessary background to the charged offenses. So those two things come together. They have to go together, guys. They have to go together. The direct evidence and the corroborating evidence must come together. So I don't know. It looks like Auntie Anne did a pretty good job ruling on what she ruled. Sounds right to me. I don't know about an appeal. Good luck. Then it says United States versus Rivera, and it cites the law, right? And this is something that happened in 2015. And then it also quotes another law in the Second Circuit that happened in 2007. And it states that when a defendant has been charged with racketeering offenses, it is well settled that the government may introduce evidence of uncharged offenses to establish the existence of the criminal enterprise. So the government, when the defendant is being charged with racketeering offenses, it is settled that the government may introduce evidence of uncharged offenses to establish the existence of the criminal enterprise. And that is just exactly what the government did. Then it cites another law, another case that happened, United States versus Carboni. And this was in the circuit, another appeal. All right. And they also quoted the United States versus Gonzalez and the Second Circuit Court in 1997. Now, these two cases has cited that evidence of uncharged criminal activity is not considered other crimes evidence under the Rule 404B. And if it arose out of the same transaction or series of transactions as the charged offense, if it is inextricably intertwined with the evidence regarding the charged offense, or if it is necessary to complete the story of the crime on trial. So it's not, the uncharged crimes are not considered other crimes. It's just a show of transactions or series of transactions to the charged offenses. And it goes together. It is important, inextricably it goes together with the evidence that is regarding to what the person's being charged with. So, or if it's necessary to complete the story of the crime that's on trial. That's why they didn't use Lizette and all the other people. They went as they needed to go, and they used certain video footage that they needed to at the particular time with the particular testimonies that matched corroborating evidence, cumulative evidence. And if it was not necessary to use those people to complete the story, then they didn't need it. They had enough with what they did. How about that? And you know what? R. Kelly's lucky that those are the only charges he got. And the only people that came to defend for the prosecution side, they were there and they did what they had to do. If they would have added on more piled stuff, R. Kelly would have really been done. So at the end of the day, he was very, very lucky. I cannot. Hold on, please. Give me a second, guys. Exactly, guys. That's why I say, when you are reading this stuff, as I said, you have to Google words, laws, or you're not going to understand what you're reading. You're just going to read, you're going to assume, and you're going to mislead the people. And you're going to continue to have people confused. Okay? This is why we have so many lost souls in this sector. People ain't doing their job the way they should be doing it. They're not. They're just rambling. Fucking Blues Clues. I cannot. Okay? Oh, man. It hurts my soul. It hurts my soul. Because let me tell you something. I'm not for R. Kelly. Y'all know I'm not for R. Kelly. I'm not. I'm glad he's where he is, off the streets. Okay? Now, but I feel so bad for the supporters. A lot of them are so misguided. And then with Choke No Joke on the scene, oh, they're even more misguided. It is crazy. It's like, I say to myself, damn, we just finished kind of like having everybody come to some kind of understanding as to what is going on and how he was being charged and what the charges really meant. And you know what I'm saying? That it got to a point where Debo, who we all know is crazy, was like, now I get it, now I understand. But he still feels it's not fair. Props to you, Debo, for that. You know, one man can be an enterprise. And we figured out what happened. An individual can be charged as long as he has people aiding and abetting for him. That's all he needs. That's all he needs. All he needs to do is sit back in his Tony Montana throne of a chair with his crown tilted to the side, snapping fingers like this. That's all he had to do. He didn't have to be involved in certain crimes. All he had to do was go. And everybody jumped and said, how high? And then they came falling down. Okay. So that's how that goes. That's how the cookie crumbles. Okay? Okay? Like, these people are crazy. Like, we just came to an understanding to where they kind of understood the law. You know? Everybody was scrambling for lawyers and all types of things to talk about the case and learn. And they still didn't listen. Oh my God. They were still listening to whatever they wanted to hear. It's crazy. So it was happening. And now all of a sudden, Choke No Joke comes into the picture. And we're back to square one, 2019, starting all over again. It's a repeat of 2019, and we're going into 2022. And for the life of me, I don't understand why are we still going back in time. But it is what it is, because we are going back on time. On R. Kelly. We're going back in time on R. Kelly. We sure are. So, they just like to repeat themselves. I don't know, make up new stories, add things, subtract things. They do a whole lot of things. Lord, have mercy. Yes. Thank you, guys. Thank you. You know, it's crazy. And don't forget, guys, for those who don't want to donate to the Super Chat, you could always donate to my Cash App, my Zelle, or to my PayPal. The information is scrolling underneath the screen, okay? Just to let you guys know, Mama likes to get her money today, too. Not a month from now or 2 months from now. I got to pay bills every month. I love you guys. You know, so, you know, we that's what it is. So let's go to the next page. Now, where was part 3? Matter of fact, I missed that part. Where was it? Where was at 3? Here it is, right here. Now, this is 3. Now, in number 3, the little subparagraph, you know how I was showing you guys the little subparagraph, right? It says that the sole purpose, which omits all other acts, evidence that does not serve the sole purpose of showing the defendant's bad character and that is neither overly prejudicial, nor irrelevant. Prejudicial nor irrelevant. So then it says to go down to subparagraph 3, and we'll find out what that's about. There. Here we are. And in this paragraph, it says that the standard of proof.
Yeah.
Yes, baby.
Yeah.
Hold on a second. Okay, sorry about that, guys. I'm back. All right. So it says that in this subsection, part number 3, it says that the standard of proof under the Rule 404B is whether a jury could reasonably conclude by a preponderance of the evidence that the act occurred and that the defendant was the actor. And then it cites a case law, Boyce versus Weber. And it tells you the case law there. And it was from the Southern District of New York, July 7th of 2021. And it also quotes the United States versus Gillian.
Yeah.
And it's from the Second Circuit of 1992. The Second Circuit Court of 1992.
Yeah.
Hold on.
Around.
All right. Now, this last sentence said that the evidence regarding the charged offenses, or if it is necessary to complete the story of the crime on trial. And continues to say that Rule 413 permits. That Rule 413 permits. Yeah, okay. That Rule 413 permits certain propensity evidence in the specific context of sexual assault cases. In a criminal case, which a defendant is accused of a sexual assault, the court may admit evidence that the defendant committed any other sexual assault. So, as long as the evidence is relevant, and they recite Federal Rule 413A. Now, under Rule 412, evidence offered to prove that a victim engaged in other sexual behavior, or evidence offered to prove a victim's sexual predisposition, generally is barred. So, okay, let's see. Rule 412. Let's see. Okay. All right, now it said 412, right? Okay, wait, 413A. Okay. So in 412, Rule 412 is sex offense cases, talks about the victim. A talks about prohibited uses. The following evidence is not admissible in a civil or criminal proceeding involving alleged sexual misconduct. 1. Evidence offered to prove that a victim engaged in other sexual behavior, or 2. Evidence offered to prove a victim's sexual predisposition. And then it says that in Part B, that talks about expectations. But we're talking about the prohibited uses. So they're saying that, you see how R. Kelly was saying that he wanted to use a defense about the girls' histories, you know, their sexual past and things of that nature, like what they were doing with Faith Rogers, right? That the following evidence of is not admissible in a civil or criminal proceeding involving the alleged sexual misconduct. Okay, the evidence offered to prove that a victim engaged in other sexual behavior, or evidence to prove that a victim's sexual predisposition. So that's what that talks about there. Right? And it's Part A, like I said, so I just read that. So that it says that the rule identifies 3 specified exceptions. I, which is number 1, evidence of specific instances of a victim's sexual behavior, if offered to prove that someone other than the defendant was the source of semen, injury, or other physical evidence. 2, that evidence of specific instances of a victim's sexual behavior with respect to the person accused of sexual misconduct. Now, if offered by the defendant to prove consent, or if offered by the prosecutor. And 3, evidence whose exclusion would violate the defendant's constitutional rights. Now, in the Rule 412B and 1, it says that if the defendant intends to offer Rule 41B as evidence, right, he must move to do so at least 14 days before trial, unless the court, for good cause, sets a different schedule. And the motion must specifically describe the evidence and state the purpose for which it is to be offered. Now, under Federal Rule 412C, it says that the defendant also must serve this motion on all parties and give notice to the victim. So this all falls on the defendant when he talks about the 412 as far as towards the victims and showing evidence towards the victims, right? And it says that finally, hearsay, an out-of-court statement offered for the truth of the matter it asserts is inadmissible unless it falls within an enumerated carve out or exception. And as we know, what was enumerated again? Unless it falls upon facts, upon facts, upon facts, right? The preponderance of evidence. Then it talks about Federal Rule Evidence 801, 802, and 803. Then last is her discussion. She talks about here her discussion next. And it says request to admit certain evidence. A, sexual contact with Jane Doe, number 1, a minor in 1994. So there was a request to admit certain evidence, and sexual contact with Jane Doe, number 1, as a minor in 1994 was submitted into evidence, and that the government moved to admit evidence that the defendant had sexual contact with Jane Doe, number 1, in 1994 when she was a minor. And then here it's going to go under Section 4. So we know Section 4 is down here somewhere. Now, motions document number 133 at paragraphs 13 and 14. Or pages 13 and 14. Pages 13 and 14. Pages 13 and 14. The motion was granted. The motion was granted by the government to admit Jane Doe, number 1, 1994, and her sexual contact with Kelly. Now, part of that was part of in the Racketeering Act 1. Now, the defendant was charged with bribing a public employee. And then this motion is number 43 at paragraph 13. Now, according to the government, the defendant and his associates bribed a public official so that the defendant could marry Jane Doe, number 1, as part of an effort to conceal the fact that he had sexual contact with her when she was 15 years old. And then it says about the motion 133, and this is at page number 14. So evidence of the defendant's sexual contact with Jane Doe, number 1, was inextricably intertwined with the evidence of the bribery and established the motive for it. So the evidence was therefore relevant and not barred by the Rule 404B. Nor was it barred by 403. It was relevant and probative for the reasons just discussed and was no more inflammatory than the charged offenses. Okay? So now it talks about the United States versus Rivera, and this was in the Eastern District of New York, a case in 2015. And then they're going to also quote the United States versus Livati, another case that was in the Second Circuit Court in 1999. So it states that the evidence shall be excluded as unfairly prejudicial when it is more inflammatory than the charged crime. And she's saying that it wasn't. So B talks about sexual contact with Jane Doe number 7, a minor, in 1991. Okay? Jane Doe number 7, as we know it to be our girl, JoJo. And it says that the government moved to admit evidence that the defendant had sexual contact with Jane Doe number 7 when she was a minor, and that Jane Doe number 7 observed the defendant having sexual contact with Jane Doe number 1. Now, remember what I was telling you about that paragraph about number 1? It just says Jane Doe number 1 is deceased. So just letting us know that she's deceased. So it says that Jane Doe number 7 had said that she knows that Kelly the defendant had contact with Jane Doe number 1. And they talk about it in document number 143 document number 133 at 14. So at page 14 or at line 14, one or the other. I think it's page. Now, in supplement briefing on this request, the defendant argued that the evidence was needlessly cumulative. There goes number 5. So that should be down here somewhere too. Now, number 156, another document at page number 2, talks about that on August 18th, 2021, before opening arguments, I granted the request in part and denied the request in part. Now, she talks about the trial transcripts. Page 4 says that I found that evidence that Jane Doe number 7 witnessed sexual contact between the defendant and Jane Doe number 1 was admissible for the same reasons that evidence of the defendant's sexual contact with Jane Doe number 1 was admissible. I also found that evidence of the defendant's sexual contact with Jane Doe number 7 was not admissible because it took place before the enterprise began. Now remember, her situation was 1991. They were going as far back as 1994. So that's irrelevant. So therefore, it's not admissible evidence. So the sexual contact with R. Kelly was irrelevant. It was not admissible because it took place before the enterprise began and was needlessly cumulative. In other words, it was repetitive on top of, right? Like what I said before, right? Cumulative, right? Now, on September 4th of 2021, the government renewed its request to admit evidence of the defendant's sexual contact with Jane Doe number 7, arguing that it was inextricably intertwined with the evidence the court had ruled admissible, and made an additional proffer that when the defendant had sexual contact with Jane Doe number 7 and other minors, his associates knew what the defendant was doing. And that was in document number 192. And the defendant opposed in document 202 that on September 9th, 2021, she said, I granted the government's request. So the court ruled admissible and made an additional proffer that when the defendant had sexual contact with her and other minors, his associates knew. So she granted the government's request. And that talks about it in the trial transcripts on pages 280, 2,848 to 2,850. Now, the government's additional proffer made clear that the evidence was inextricably intertwined with Jane Doe number 7's account of witnessing sexual contact between the defendant and Jane Doe number 1, and was additional relevant evidence of the enterprise's means and methods. And then it states another case law, Boyle versus United States. This happened in 2009. And it says that an association, in fact, enterprise must have a purpose and relationships among those associated with the enterprise. So accordingly, the evidence was neither unduly prejudiced. Accordingly, the evidence was neither unduly prejudiced nor cumulative. So then in 6th section over here, when we were talking about number 5, that was down here. That was talking about in supplemental briefing of this request, the defendant argued that the evidence was needlessly cumulative. So it talks about that here.
I just got access to every offshore account my uncle owns.
Now it says that in 5 that there was no need. Now the defendant was putting this in, saying that there was no need for a further evidentiary hearing, and that it talks about this in document 156 at page 2, and that the parties briefed these issues and had an opportunity to make their arguments during the August 3rd, 2021 pretrial conference. Moreover, as stated above, ruling on motions in limine are subject to change as a trial unfolds. So in other words, that they were too late. They could have made changes or did other things and they didn't. The defense team did not do the job. They did it. Period. Punto. Point blank. Like she said, they had space and opportunity, time and opportunity, and they waited too goddamn long. Oh, well. That's not my fault, not my problem. I go by the law. Then she talks about C, which was sexual contact with Jane Doe number 8, a minor in 1994. Now, the government moved to admit evidence that the defendant had sexual contact with Jane Doe number 8 in 1994. I don't know. Wait, Papi, you got the lighter there?
I don't know. Yeah. I feel.
Okay. Now, Jane Doe number 8. I'm trying to figure out for the life of me, Jane Doe number 8 in 1994, when she was a minor. Specifically, the government sought to present evidence that Jane Doe number 8 was at the defendant's concert. Jane Doe number 8 and that one of the defendant's associates directed her backstage where she had sexual contact with the defendant. Is that Stephanie? No. Who was Jane Doe number 8? Okay. Anybody know who Jane Doe number 8 was? Hold on.
Yeah.
Okay. Guys, when you see that happens, please report it. Thank you. When that happens, please report it, guys. Thanks. That's them Russians. They be coming over here spamming my ass. So now it says that sexual contact with Jane Doe number 8, a minor in 1994, the government moved to admit evidence that the defendant had sexual contact with Jane Doe number 8 in 1994 when she was a minor. And it talks about that in document number 133 at pages 14 and 15. Specifically, the government sought to present evidence that Jane Doe number 8 was at the defendant's concert and that one of the defendant's associated directed her backstage where she had sexual contact with the defendant, and the request was granted. So she granted that request, right? And it says that this evidence was direct evidence of the enterprise and its means and methods. It was direct evidence because she was at the concert. Somebody told her to come backstage. She went backstage. She was abused and then went back home like, okay, you know. Now it says that this evidence was direct evidence of the enterprise and its means and methods to establish an association. In fact, enterprise within the meaning of the 18 U.S. 1961-4, and the government was required to prove beyond a reasonable doubt, among other things, a person and relationships among those associated with the enterprise. And then it cites another, the case of Boyle, and they talk about the page 946. The indictment charged the defendant with leading an enterprise that included the defendant, his entourage, and others, and charged that the purpose of the enterprise was to recruit women and girls to engage in illegal sexual activity with the defendant, including by recruiting women and girls at concerts. And then it states in document number 43 at paragraphs 1 through 4. Then it says that the evidence of the defendant's encounter with Jane Doe number 8 was probative of the existence of the enterprise and the way it operated. So thus it was relevant and not barred by Rule 404B. So finally, this evidence was not unduly prejudicial. It was no more inflammatory than the charged offenses, and did not raise other Rule 403 concerns. Now, sexual contact with Jane Doe number 9, a minor, in 1995. The government moved to admit evidence that the defendant had sexual contact with Jane Doe number 9 in 1995 when she was a minor. It talks about that in document 133 at page 15. And in particular, the government sought to introduce evidence that the defendant began a sexual relationship with Jane Doe number 9 when she was 17 years old. That the defendant slapped her when she laughed at another man's joke. That she contracted herpes from the defendant. And that she told him that he had given her herpes. It talks about that in document 133 at page 15. And in supplemental briefing, the defendant argued that this evidence was needlessly cumulative. And then it talks about that in document 156 at page 2 or paragraph 2. The request was granted in part and denied in part. So evidence that Jane Doe number 9 had a sexual relationship with the defendant in 1995, contracted herpes from him, and disclosed that she had herpes to him. That she had herpes to him? Okay. And disclosed that she had herpes to him. I read that wrong. Now, that was admissible to show that the defendant knew he had herpes. Now, which was charged in Racketeering Acts 8, 12, and 14, as well as in counts 6 through 9. Now, documents number 43 at paragraph 22 through 24, 32 to 34, 36 to 38, and 43 to 46. Now, the evidence was therefore relevant under the federal rule evidence of 401, 404B. Now, the evidence was not unduly prejudicial. It was not more sensational than the charged offenses, and it did not raise other Rule 403 concerns. So, evidence that the defendant slapped Jane Doe number 9 when she laughed at another man's joke, although relevant, was needlessly cumulative. So it was fact upon fact, but you couldn't find the fact. Yeah, no. So E is exposure of Jane Doe number 11. I need something to drink. Give me a second, guys. Okay. Now, E talks about exposure of Jane Doe number 11. All right. You know what, guys? I think I'm going to give myself a little minute and let the reader read just a little bit. Okay? All right. I can't do the read aloud. Let's see. Oh, okay. I think I have to make it smaller because it should do it. There we go. Okay, now I'm sorry. There we go. I had to take off the highlight. That's what it was. Okay, so
Other Rule 403 concerns. Evidence that the defendant slapped Jane Doe number 9 when she laughed at another man's joke, although relevant, was needlessly cumulative. Federal R. Evid. 401, 403. Exposure of Jane Doe number 11 to a sexually transmitted disease in 2001. The government moved to admit evidence that the defendant had sexual contact with Jane Doe number 11 without disclosing that he had herpes, that Jane Doe number 11 told the defendant she believed she contracted herpes from him in 2001, and that Jane Doe number 11 entered a financial settlement with the defendant. ECF number 133 at 17. In supplemental briefing on this request, the defendant argued that evidence of the settlement should be excluded because the jury would interpret it inappropriately as a concession of guilt, and because allowing the settlement agreement into evidence would send a chilling effect to any future settlements. ECF number 156 at 1, ECF number 164 at 1 to 2. Citing Rule 701(c), which prohibits a lay witness from testifying based on scientific, technical, or other specialized knowledge within the scope of Rule 702, the defendant also argued that Jane Doe number 11 should not be permitted to testify that she contracted herpes from the defendant. ECF now. 164 at 1 to 2. The government responded that the settlement agreement was admissible under Rule 408. ECF number 162 at 2. 9. The government's request was granted. Evidence that Jane Doe number 11 told the defendant that she believed she contracted herpes from him was relevant. It was evidence that he knew he had herpes, which the government was required to establish beyond a reasonable doubt to prove Racketeering Acts 8, 12 and 14, as well as counts 6 through 9. ECF number 43 paragraphs 22 through 24, 32 to 34, 36 to 38, 43 to 46, Federal. R. Evid. 401, the defendant's Rule 701 argument was unavailing. Jane Doe #11's testimony about her interactions and communications with the defendant, and about her own medical status, is not expertise within the meaning of Rule 702. Jane Doe #11's settlement agreement was also admissible. It was evidence of the enterprise and its means and methods, in particular, the efforts the enterprise undertook to conceal and perpetuate the enterprise. Federal R. Evid. 401, nor was it precluded by Rule 408. While evidence of a settlement agreement to prove the validity or amount of a disputed claim is not admissible, Federal R. Evid. 408 AT, he court may admit this evidence for another purpose. Federal R. Evid. 408b. In this case, the agreement was admissible for a purpose other than to prove or disprove the validity of the claims that the agreement was meant to settle. Westside Winery Incorporated v. SMT Acquisitions LLC, number 19 CV 4371, 2020 WL 841, 3554 at *4, EDNY November 5, 2020, quoting in re-subpoena issued to Commodity Futures Trading Com. 370F, Sup. 2D 201, 210, DDC 2005. As discussed above, the agreement demonstrated the defendant's efforts to conceal the enterprise and was thus admissible. 6. Moreover, it is not at all clear that the settlement agreement was legal or enforceable. See Beth Israel Med, Center v. Horizon Blue Cross and Blue Shield of New Jersey Incorporated, 448 F.3D 573, 580, 2 DCIR 2006, contracts for an illegal purpose or contrary to public policy are not enforceable, Cosby v. AM. Media Incorporated, 197 F. Sup. 3D 735, EDPA 2016, finding settlement agreement unenforceable as violative of public policy to the extent it prevented parties from cooperating with a criminal investigation, Royce v. Michael R. Needle, PC 381F, Sup. 3D 968. 990, NDL 2019, private agreement, S, contrary to public policy are not in force, able, 23 Federal Prac. And PROC, Evid. Section 5314. 10. F. Sexual contact with Jane Doe number 13, a minor, in 2006. The government moved to admit evidence that the defendant had sexual contact with Jane Doe number 13 in 2006, when she was a minor. ECF number 133 at 18. According to the government, the defendant met Jane Doe number 13 at a concert when she was 15 years old. ID, he began a sexual relationship with her and directed his associates to arrange Jane Doe #13's travel to visit him in Chicago. ID, the request was granted. The proposed evidence was direct evidence of the enterprise, its purposes, and its means and methods. It was therefore relevant and not barred by Rule 404(b). The proposed evidence was admissible under Rule 403, it was probative of the enterprise and no more inflammatory than the charged offenses. G. Sexual contact with John Doe number 1, a minor, in 2006. The government moved to admit evidence that the defendant had sexual contact with John Doe number 1 in 2006, when John Doe number 1 was a minor. ECF number 133 at 18 to 19. The government sought to present evidence that the defendant promised to help John Doe number 1 with his musical career, began a sexual relationship with him, and directed him to engage in filmed sexual encounters with others. ID, the request was granted. This evidence was direct evidence of the enterprise's purposes, as well as its means and methods. The indictment charged, among other things, that one of the purposes of the enterprise was to produce pornography, including child pornography. ECF number 43 paragraph 2. Thus, the evidence was relevant and not barred by Rule 404(b). Finally, the evidence was not unduly. 2D addition. If the compromise agreement is itself illegal, evidence of this is admissible under Rule 408. 11. Prejudicial. It was no more inflammatory than the charged offenses and did not raise other Rule 403 concerns. H. Threats toward employee number 1 and settlement payment to Jane Doe number 15. The government moved to admit evidence that the defendant threatened employee number 1, a talent manager, and that he entered into a settlement agreement with Jane Doe number 15. ECF now. 133 at 19 to 20. In particular, the government alleged that the defendant met Jane Doe number 15 through her talent manager, employee number 1, when Jane Doe number 15 was 17 years old, and that the defendant promised to act as a mentor to Jane Doe number 15 in the music industry. ID, the government also moved to introduce evidence that Jane Doe number 15 subsequently accused the defendant of sexually abusing her, that the defendant threatened and intimidated employee number 1, causing her to sign an affidavit falsely stating that she did not witness the defendant do anything inappropriate to Jane Doe number 15, and that the defendant reached a financial settlement with Jane Doe number 15. ID, in supplemental briefing, the defendant argued that the evidence was needlessly cumulative. ECF number 156 at 2. The government's request was granted. The evidence showed the enterprise's means and methods, specifically, it showed the enterprise's efforts to perpetuate and conceal the enterprise. Thus, the evidence was relevant and not barred by Rule 404(b). Nor was it unduly prejudicial because it was no more inflammatory than the charged offenses. I. Abuse of Jane Doe number 18 from 2016 to 2017. The government moved to admit evidence that the defendant abused Jane Doe number 18, psychologically and physically. ECF number 133 at 21 to 22. According to the government, Jane Doe number 18 began a sexual relationship with the defendant after one of his associates approached her at a concert. ID, the defendant then subjected her to his rules and punished her, including physically, when he perceived that she had broken them, directed her to write letters. 12. containing embarrassing false statements about herself, and directed her to have sex with him and others, which was filmed. ID. The request was granted. This was direct evidence of the enterprise, its purposes, and its means and methods. It showed the defendant's control over his associates and the victims of the enterprise. It also was inextricably intertwined with evidence of the charged offenses involving Jane Doe No. 5. The proposed evidence was also admissible under Rule 413 and was relevant to the charged sexual assaults of Jane Doe No. 4, Jane Doe No. 5, and Jane Doe No. 6. Federal R. Evid. For 13, moreover, the evidence was not unduly prejudicial or otherwise excludable under Rule 403 because it was no more inflammatory than the charged offenses. J. Threats toward Jane Doe No. 6 in 2018 and 2019. The government moved to admit evidence that the defendant and his associates threatened Jane Doe No. 6 in an effort to convince her to stop speaking publicly about the defendant and to drop a lawsuit she had filed against him. ECF number 133 at 23 to 27. According to the government, the defendant and his associates threatened to release compromising photographs of Jane Doe No. 6. The threats were communicated in person, in text messages to Jane Doe #6 attorney, and through a Facebook page. ID. The request was granted. This was direct evidence of the enterprise and its means and methods, including the use of threats and blackmail to conceal and perpetuate the enterprise. It therefore was relevant and not improper Rule 404(b) evidence. Nor was it unduly prejudicial. It was no more sensational than the charged offenses or otherwise excludable under Rule 403. K. Alleged threats to Jane Doe No. 19 in 2018. The government moved to admit evidence that the defendant directed a former girlfriend, Jane Doe No. 19, to sign a non-disclosure agreement and to write text messages containing 13. Embarrassing false statements about herself, and that the defendant made veiled threats to her and her family. ECF number 133 at 28. The request was denied. The proposed evidence was needlessly cumulative. Federal R. Evid. 403. There was other admissible evidence of the enterprise's means and methods. The government did not explain how this conduct related to the enterprise. L. Bribery of a Cook County clerk in 2019. The government moved to admit evidence of a conversation between the defendant and his crisis manager after the release of a television show about the defendant and while law enforcement was.
Boy, I'm going through this chat right now. Y'all are, I cannot. What is going on? Okay. You see this shit here, guys? She denied certain things and she let in certain things. She was being fair. She was being a fair judge. Because she could have been a real bitch and threw everything on him. But she was going according to the law. You see? She was a very fair judge. And it just so happens to be that everything that she submitted and granted, everything that she granted, shall I say, that the government submitted had corroborating, intertwined evidence. So under the rules of 404, the rules of 400s, in the 400s, states that you can use it. There's no law saying that you can't unless it's not corroborating evidence. If it doesn't intertwine together, you can't use it. If it's irrelevant, you can't use it. Period. Now, the bribery of a Cook County clerk in 2019, guys. What do you think about this? Look. Okay, see? Now, over here, we are smart over here. Hold up. Let me go down. So these comments here, you guys are on a roll. Boom! Jane Doe 18, Hallie. Boom! Number 11, Kate. 13, Alexis. 15, Precious Way. Andrew, I'm going to give you a fucking... man, you know what? I'm going to cash app you right now just because you so goddamn smart. What's your cash app, bro? I'm going to cash app you $5 just for getting all of them right. Somebody's paying attention. Yes, this is what we need. People who really pay attention. Holla back, Andrew. What's your cash app, bro? I'm dead ass. I'm going to send you $5 just for knowing all that. Just for knowing all that, bro. Just for knowing all that. What's your cash app, Andrew? I'm not playing. I'm dead ass. Andrew, do me a favor. Type in on one line all the girls so I could pin it to the chat. Because I wanted to do that. Damn it. Damn. Come on, Andrew. Where you at? Where you at, brother? Where you at? Let me. Where you at? Where you at? We're gonna do. All right, Andrew. Wait, I gotta get one better than that. Yes, Andrew, yes. 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 Yes, Andrew, yes. You go, boy. Okay? Andrew, are you typing or are you hiding? What happened to you, bro? All right, Andrew, I'm going to wait for you to come in. Shout out to Jim D. Yes. Shout out to D-Row. D-Row, when you get a chance, we talked about it. You're going to come on and see me when you get a chance. We want to thank you over here. I told you, I really want to thank you. Andrew. Okay. He's got him. He's got him. Uh-huh. All right. All right. Now here talks about the bribery of a Cook County clerk in 2019. We all know that this is Mr. Daryl Johnson, like the Johnson & Johnson baby powder, the one that we just found out that he's being charged with stealing money, fraud. And it says that the government moved to admit evidence of a conversation between the defendant and his crisis manager. And after the release of a television show about the defendant, and while law enforcement was investigating the defendant, and it talks about it in document number 133 at page 28 to 29 or line 28 to 29. Then it says that according to the government, the crisis manager told the defendant that he had two people who know a lot and that the defendant should figure out what you can do for them. The defendant responded, "What you do, man, is write something on a piece of paper and give me what I should tip the bailiff, what I should tip the valet. Like when my uncle come up here and say, Rob, the valet guy, he parked the car over there. I say, so what should I give him? And he'll say, well, $20, $30. I give him $30. So what I'm saying is I don't know that number." Then the crisis manager also told the defendant that he had paid a clerk in Cook County $2,500 and given the clerk a burner phone to communicate information about the ongoing investigations. Now remember, guys, back in the day, R. Kelly got a burner phone in Chicago. Somebody snuck it in and gave it to him, right? Along with a letter. Remember that? Okay. Just remember, R. Kelly always has a burner phone. Just remember that. Okay? Just remember that. Okay? How many phones did he have? 100 plus devices, including iPads, cell phones, you know, cameras. Okay? Okay. Now, a burner phone to communicate information about the ongoing investigations. Now, the crisis manager said, that's done. You don't know nothing. To which the defendant replied, exactly. So according to the government, this conversation was evidence of the defendant's willingness to bribe someone and therefore was probative of the continuity of the enterprise. Okay? Again, more evidence, preponderance evidence to show that he still works as an enterprise. He's still working with his enterprise. Even while in jail, he's still committing crimes. Now look how nice the judge was. The request was denied. Judge Donnelly, Auntie Anne was nice. She was fucking nice. Oh man, I didn't mean to curse. I've been doing good, Lord. The request was denied. What do you know? The judge was nice. Holy cow. He could have had another charge. How about that? But unfortunately, what's his name? The baby powder decided to skip town somewhere. They looking for him, right? Now it says that the proposed evidence was marginally relevant because it went to the means and methods that the enterprise undertook to conceal and perpetrate itself. But it was too tedious to be admitted. Tenuous. Let me see what's tenuous. What does tenuous mean? Let me see.
Tenuous.
Means very weak or slight. So they said, she denied it because, even though it was a proof, some type of proof to show the means and methods of his enterprise, that they conceal evidence, right? And things of that nature. They lie and they do all these sneaky things and commit crimes. She said it was too weak to be admitted. Now, while the evidence demonstrated the defendant's willingness to bribe someone, there was no proof that he actually followed through. That's why it was tenuous. There was no proof. So, for these reasons, the proposed evidence had the potential to confuse the jury and was not admissible under the federal rule evidence of 403. So she went according to the law. She did what she had to do. She did the correct thing by not admitting that. M talks about there you go. Wait, I'm going back here. What are you guys doing? Okay. Jane Doe 16. Juice, Jane Doe 17. Dominique. 18. Heather Jane Doe 19. V. Andrews. JD number 20. Send another 5 to Andrew. Jane Doe number 20 was Lisa Van Allen. That's right. I was watching Dry Fox earlier and she was being sarcastic, I think, saying that they made a mistake where it says Jane Doe number 8 should be Jane Doe number 5 because she is a stripper. No, Jane Doe number 8 was Addie, right? Andrew was Addie. Yeah, I think it was Addie. And Jane Doe number 8 listed was Addie. Now, Addie was the one who met R. Kelly in the background with her friend. Isn't that the one that was with the friend? Or was it her by herself? Oh, shit, I don't remember. I don't remember what. Was it by herself? Or was she? That's the one that was with her friend and they kissed each other or something, right? I don't remember totally everything, but yes. But yes, Andrew, you on a roll. She was trying to save his ass. Hey, 100, what's up, mama? Hey, Charlotte. And what's up, Andrew, once again? Okay, Andrew, I see you don't have your cash out there, huh? All right, I love you too, boo. Thank you for your information. You see, I love it when people pay attention. Right, she was with her. That was the one that was with the friend. Okay, yeah, that was the one that was with her friend. Right. When I saw Sly Fox doing that, I was like, what in the world? I was like, what is she talking about? She got the girls all mixed up. I was like, what is she do? I cannot get her off. Get her off. Get her off. Boo! Throw tomatoes. Throw tomatoes. Boom! You don't know what you're talking about. Boo! Throw tomatoes. Throw tomatoes in her face. Like, hello. Y'all be bugging. That's why I said they do nothing but misinform the people. Okay? Yeah, exactly. We do research over here. For real, for real. Like, for real, for real, for real. I bet you my shit is not as loaded as, I bet you your shit is not as loaded as mine. I could bet you that. I could bet you that. I could bet you that. You over here going on ass. Punto. Okay? Okay. Now, it talks about bringing up the 2008 trial, right? The defendant's 2008 state criminal case. The government moved to admit evidence that the defendant was tried on child pornography charges in 2008 in Cook County, Illinois, and that he tried to influence one of the jurors. Now, that also was spoken about in document number 133 at number 29 to 30. I don't know if that's line 29, line 30, or 29 to page 30. And then it says that the request was denied. She denied that. She's like, no, we're not gonna add anything about his 2008 case, because technically this is not the place to bring up his 2008 case. His 2008 case had to deal with the state over there, and the federal of Chicago will deal with that next. So I can't bring that up here. We can't do that here. So that is all irrelevant. Even though he was doing his modus of operandi at that time, it still was denied because this evidence was not relevant to the alleged enterprise. It had nothing to do with the enterprise. It had to do with child pornography, him and a minor. That's it. That's all. So it's not relevant to bring it up. It's irrelevant. It doesn't even matter. That's not the case over here. Over here, we're talking about racketeering. We're talking about Mann Act. That's what we're talking about. So it says, moreover, it was impermissible propensity evidence and cast the defendant as a long-time subject of suspicion. Okay? Now, N talks about the defendant's effort to obtain child pornography, which is what happened in 2008, right? Now, it speaks that also the government moved to admit evidence that Jane Doe number 5 obtained child pornography for the defendant at his direction. And they spoke about that in document number 133 at 3031. Now, remember that they're talking about when she looked online for the pornography of the boys having sex with boys, right? Remember when they spoke about that in the document? That she went and looked up child pornography for him in 2019, right before he went to jail, in January or something like that, right? And that it was at his direction that he asked her to do it. That evidence the request was denied. Now they're saying that this evidence was not admissible and it was not clearly relevant to the government, clearly relevant, and that the government did not demonstrate that the allegation related to the enterprise or its ends. And that was under the Federal Rule of Evidence 401. And moreover, the evidence was unduly prejudicial and potentially confusing. So, especially given the government's concession that the people in the recordings at issue might not be children. And it talks about that in document 133 on page 31. Oh, give me a second, guys. Pause. Oh, happy birthday, Brooke. You're welcome, Mama. Happy birthday, Mama. You know I still love you, Mama. My loca. You the crazy lady. It's so good. I hope you had a good birthday, Mama. Well, so now, now, here we go. Audio recordings of the defendant's physical abuse and threats. The government moved to admit 2 recordings in which the defendant yelled at and physically assaulted women, including Jane Doe number 20. And it talks about that in document number 133 at 31 and 33. Now, in one of the recordings, the defendant berated and threatened Jane Doe number 20. Now, we know that's Lisa Van Allen. And the request for that was granted. Now, this was direct evidence of the enterprise, its purposes, the means and methods, and of the defendant's participation in the enterprise. Now, the proposed evidence demonstrated the defendant's control over victims of the enterprise and others, as alleged in the indictment. Now, do you guys remember what it was that happened in the audio? It was for Jane Doe number 20, for Lisa Van Allen. All right? It had showed that he yelled at her for stealing. Then it showed that he took her off camera, physically beat her in the other room. Right? And his boy was with the camera talking to him like, what we going to do with her? Right? If I'm not mistaken, I'm eating my food, guys. Right? Thank you, Blade. Yes. Oh my God, who fell out of heaven? Who fell out of heaven? Wait a minute, I'm looking at the comments now. Who fell out of heaven? Yes, he peed on her. And she's like, and the other girl, that was Haley. That was Hallie, that he peed on Hallie. And the other girl's there with her. Or I don't remember if it was her or another girl that was there. That was like, oh, it's just splashing so much, or it's splashing everywhere. Oh my God. Okay. Okay, see what? See from, Out of heaven. Oh, she fell out of heaven. Now, it has stated that the evidence was no more inflammatory or sensational than the charged offenses. So, as it was alleged to depict conduct similar to the conduct charged, and the proposed evidence was not otherwise excludable under the 403 rule. And then they're going to talk about Jane Doe number 5. She goes to talk about her. She says, well, the government moved to admit text messages, right, that Jane Doe number 5 sent to her mother and friends. And they talk about that in number 135, document 135 at 18 to 20. Probably pages 18 to 20. And it says that because the admissibility of these texts turned on trial testimony, she reserved this decision for the trial. Okay. She reserved that. She put that on reserve. Auntie Ann was like, hold up, wait a minute. Yeah, we got to put that on hold. We got to reserve that. And that's definitely going to come out. That just says that at trial, the text messages were admitted without objection. You hear? They were admitted without objection. And it talks about the text messages in the trial transcripts on pages 800 through 801, also 811 through 817, 822 to 824, 830 to 836, 883 to 889. Oh, no, I'm sorry, 883, then 889 to 890, also 893 through 96, 898 through 99, and then 1386 through 1387, and also in 3656. That's where it talks about the text messages and stuff. So, my phone is dying. Where is that? Oh my Lord, I need to charge. Like right now. All right, now my phone is charging. So, now I'm going to let the reader read a little bit. Let her finish talking what she needed to say. Let's see here.
3656, Q, employees' text messages. The government moved to admit text messages of 2 of the defendant's employees that recount, among other things, their observations of the defendant's interactions with them and with others. ECF number 135 at 21 to 26. Because the admissibility of these texts turned on trial testimony, I reserve decision for trial. At trial, the text messages were admitted without objection. TTR 2015 3402-03, 3414, 3418, 3421 to 22, 3428 to 29, 3490. R. Defendant's text messages. The government moved to admit the defendant's text message that his world was huge and had many rules. ECF number 135 at 27. The request was granted. It was admissible as the statement of a party opponent, Federal R. Evid. 801 D2 and relevant to the enterprise's means and methods, Federal R. Evid. 401, it was not unduly prejudicial and did not otherwise violate Rule 403. 16. S. Electronic note. The government moved to admit evidence of an electronic note that Jane Doe No. 5 wrote on a cell phone in August 2018 containing a list of the defendant's rules. ECF number 135 at 3536. The request was granted. The note was not hearsay. Rather, it was offered to show the existence of the list, and that Jane Doe No. 5 authored it. It was also relevant. It went to the enterprise's means and methods and the control that the defendant exercised over Jane Doe No. 5. As Jane Doe No. 5 testified, she wrote the note. Thus, the note was admissible to show that she authored the list. The evidence was not unduly prejudicial, nor did it otherwise raise other Rule 403 concerns. T. Newspaper articles. The government moved to admit certain newspaper articles as ancient documents pursuant to Federal Rules of Evidence 803-16. ECF number 135 at 36 to 38. The articles showed that the defendant performed in Macon, Georgia on August 30, 1994, in Albany, Georgia on August 31, 1994, and in Miami, Florida on September 2, 1994. ID. The request was granted with the acknowledgement that the ruling could be obviated by a stipulation by the parties. Ultimately, the government admitted a heavily redacted version of the August 31, 1994 article concerning the Georgia concert dates without objection. TTR 3760-61, requests to exclude certain evidence. A. Prior conduct of witnesses. The government moved to preclude the defendant from...
Wait, what? Hold on. Okay. The government moved to admit certain newspaper articles as ancient documents. Pursuant to the law, Evidence 803-16, documents 135 at 36 and 38, the articles showed that the defendant performed in Macon, Georgia on August 30th of 1994, in Albany, Georgia on August 31st, 1994, and in Miami, Florida on September 2nd, 1994. The request was granted with the acknowledgement that the ruling could be obviated by a stipulation by the parties. Ultimately, the government admitted a heavily redacted version of the August 31st, 1994 article concerning the Georgia concert dates without objection. Okay, and this is in the trial transcripts on 3760 to 61. I'm eating, guys, so let's continue. Oh, excuse me.
From eliciting testimony or other evidence, and from making arguments about any victim witness past sexual behavior with anyone other than the defendant or with others of the defendant's direction. ECF number 135 at 3. 17. The defendant did not move under Rule 412(c) to introduce such evidence. Thus, the request was granted. Federal R. Evid. For 12b, witnesses' mental health histories. The government moved to exclude evidence of the prior mental health histories of certain witnesses. ECF number 136 at 9 to 12. The details were submitted under seal. The motion was granted. Although evidence of a witness.
The motion was granted. Like I said, they sealed those documents because the public cannot know the women's private health. But R. Kelly knows their health situations. The government included it. So they got permission to get their backgrounds of their health histories. So how are you guys going to sit there and say that none of these girls have herpes and that they're lying? Or that if they did have herpes, R. Kelly didn't give it to them? Really? Really? R. Kelly knows these girls have herpes and he knows he gave it to them. He was convicted of knowingly giving them herpes. How can they charge him with that if they do not have R. Kelly's medical records or the girls' medical records to match up? Huh? Answer me that. Riddle me this and riddle me that. All right, let's continue.
Witness psychological history may be admissible when it goes to his or her credibility. The crucial inquiry is the nature of the infirmity and whether the witness suffered from the problem at the time of the events to which the witness is to testify, so that it may have affected the witness' ability to perceive or to recall events or to testify accurately. United States v. Wilson, 493 F. Sup. 2D 464, 467, EDNY 2006. Nothing in the parties' submissions showed that any witness' mental health history implicated that witness' ability to perceive or recall. See evidence about the victim's parents. The government moved to preclude the defendant from introducing evidence that the parents of certain victims permitted them to spend time with the defendant or tried to profit from their child's relationship with him. ECF number 135 at 12 to 14. This request was granted in part and reserved in part for trial. At the August 3, 2021 hearing, the government represented that it did not intend to call any of the witnesses' parents. HRGTR 46:6-12. Because a parent could not consent to the charged conduct, questions to victim witnesses about whether their parents consented or permitted the defendant to have sexual contact with them would have been improper. Federal R. 18. Evid. 401. However, questioning with a good faith basis about a coordinated extortion scheme was permissible, including for impeachment. 7D evidence of the defendant's prior good conduct. The government moved to preclude the defendant from introducing evidence of his prior good conduct, including evidence of music awards or honors. ECF number 135 at 14. Decision was reserved for trial, at which the defendant did not put on character evidence. Although criminal defendants.
Wait. So, right, questions to victims, witnesses about whether their parents consented or permitted the defendant to have sexual contact with them would have been improper. Couldn't do that because parents can't consent to their child having sex with anyone. Now, what the parents can do is consent to a relationship. I allow you to date my daughter or my son, he or she is still a virgin, and it's their choice if they give consent for you to go ahead with it. All I could do as a parent is say, I give my blessing, use protection, or sustain from having sex, give you advice, let you be about your way. It is what it is. That's the only thing a parent can do, really. Or they could try to separate you and say, no, you can't date my daughter. That's not happening. You need to go over there. You're too old. No. She might catch a stink, have an attitude, start crying. And now you have to just trust the process, right? Now, so either stay away, never look back and move forward, or will she be sneaky, conniving, run away? You know, these things happen. So, however, questioning with a good faith basis about a coordinated extortion scheme was permissible, including for impeachment. They're going to talk about that in little subparagraph number 7. So let's finish. Now remember, subparagraph 7 is going to talk about the impeachment, okay?
Defendants may present evidence of a relevant character trait or reputation testimony. Federal R. Evid. 404A2A 405, that evidence may not take the form of specific prior act evidence, or evidence that the defendant did not commit bad acts on prior occasions. United States v. Innis, number 18 CR 134, 2019 WL 699-9912 at *8, EDNY December 20, 2019. Any character evidence must be presented in a permissible form under these rules. Specific prior acts, including award or honors received, are not generally admissible. At trial, some witnesses testified about the defendant's professional achievements. See example TTR 1476-77. I ruled that defense counsel's questions about celebrities' presence at the defendant's recording studio were permissible to support the defense's argument that certain conduct and protocols the government had elicited testimony about were attributable to security needs. Evidence of Jane Doe #8's employment as an exotic dancer. The government moved to preclude the defendant from asking Jane Doe number 8 whether she worked as an exotic dancer years after her encounter with the defendant, or about her participation in a lawsuit against the owner of the exotic dance establishment for unpaid wages. ECF number 135 at 16-17. The request was granted. 7. At trial, defense counsel asked some of the witnesses questions along these lines. See example TTR 1105-06. Defense counsel asked a witness about her parents' efforts to get the defendant to engage in business endeavors. 19. This evidence was inadmissible. It was not relevant to or probative of Jane Doe #8's truthfulness. See United States v. David, number 04CR68, 2007 WL 971-7514 at *1, CD Cal. June 27, 2007, precluding evidence that government witness worked as an exotic dancer because nothing about the job connotes veracity or a lack thereof. See also Federal R. Evid. 403. Identities of victim witnesses. The government moved to protect the identity of certain victim witnesses during the trial. ECF NOS 121-133. Specifically, the government sought an order, I, permitting these victim witnesses to testify using a nickname or their first name, 2, limiting references to each in open court to their nickname or first name, 3, preventing public disclosure, via cross-examination or otherwise, of their respective addresses, names of family members or exact place of employment. The government requested that these measures apply to the following victim witnesses: Jane Doe number 2, Jane Doe number 10, Jane Doe number 16, John Doe number 1, Jane Doe number 3, Jane Doe number 11, Jane Doe number 17, John Doe number 2, Jane Doe number 5, Jane Doe number 13, Jane Doe number 18, Jane Doe number 8, Jane Doe number 15, Jane Doe number 20. The defendant did not object to the request with respect to any victim witness except for Jane Doe number 5. CECF number 137 at 1, HRG. TR 53:2-54:14. The government's request was granted. The Sixth Amendment Confrontation Clause protects two primary interests: the defendant's need to investigate a witness and to elicit information that might be relevant to the jury's conclusions about the witness' credibility or knowledge. United States v. Marcus, number 5 CR 457, 2007 WL 330388, at *1, EDNY January 31, 2007, citing United States v. Marty, 421 F.2D 1263, 1266, 2 DCIR 1970. The government must provide a reason for the limitation it seeks, and the defendant then must demonstrate a particularized need for disclosure. The court 20. Weighs the defendant's need against the risks to the witness. ID at 1, citing United States v. Bennett, 409 F.2D 888, 901, 2 DCIR 1969, and United States v. Cavallero, 553 F.2D 300, 305, 2 DCIR 1977. The government identified legitimate and compelling reasons for Jane Doe number 5 to testify using a pseudonym. Jane Doe number 5 was expected to and did testify in explicit detail about degrading and humiliating treatment. Order on motions in limine, United States v. Martinez, 17 CR 281, EDNY December 18, 2017, ECF number 34, Kogan J. The trial garnered a lot of media attention, and there was a significant risk of humiliation and reprisals. Marty, 421 F.2D at 1266, citing Alford v. United States, 282 U.S. 687, 694, 1931 T. He reasoned to limit identifying information about a witness may be that she may be subject, ed. to reprisals. The defendant argued that identifying Jane Doe number 5 publicly and by name would be necessary to his in-court and out-of-court investigation of her and goes to the heart of her credibility. ECF number 137 at 1-3. He further argued that permitting the limitations the government requested would undermine the presumption of innocence. These arguments are unavailing. The defendant did not identify a clear, particularized need to have Jane Doe #5's name disclosed publicly. The defendant knew who Jane Doe number 5 is and investigated her background. Nor was there any need to disclose Jane Doe #5's identity in order to impeach her. Defense counsel did a thorough cross-examination of Jane Doe number 5 about her prior statements without disclosing her name. Finally, the court gave the jury an instruction that the use of nicknames or pseudonyms is common in cases that have garnered media attention. TTR 17, Marcus, 2007. WL 330388, at *4, granting application for witnesses to testify using their first names only, and 21. Explaining that he court will instruct the jury that this is, due to the sensitive nature of the conduct, the witnesses will describe and the likelihood of embarrassing publicity. In sum, a balancing of the risks to the victim witnesses against the defendant's interests supported permitting the requested limitations. The victim witnesses testified about humiliating and explicit acts of abuse, some of which took place when they were minors. Conclusion: for these reasons, the motions in limine were granted in part and denied in part. So ordered. _______________________
was it that I said? Wait, where the hell did I just see it? Where the hell did I just see that? Wait. Oh,
I said, oh, it's still good. Look at all the bubbles.
oh, okay. Put it over there. Yeah, thank you.
I need to take it a few days ago. It's still
Oh, I forgot about that.
Yeah. Damn, let me take it upstairs.
Okay. What was it? Okay. The Sixth Amendment Confrontation Clause protects two primary interests: the defendant's need to investigate a witness and to elicit information that might be relevant to the jury's conclusions about the witness's credibility or knowledge. Then it says that the government must provide a reason for the limitation it seeks, and the defendant then must demonstrate a particularized need for disclosure. The court weighs the defendant's need against the risk to witnesses, and the government identified legitimate and compelling reasons for Jane Doe number 5 to testify using a pseudonym. And Jane Doe number 5 was expected to and did testify in explicit detail about degrading and humiliating treatment. Now, order on motions in limine in the United States versus Martinez, the trial garnered a lot of media attention, and there was a significant risk of humiliation and reprisals. Then it says Martin, and it cites the Alford versus United States, that the reason to limit identifying information about a witness may be that she or he may be subjected to reprisals, right? So the defendant argued that identifying Jane Doe number 5 publicly and by name would be necessary to his in-court and out-of-court investigation on her, and goes to the heart of her credibility. Then it talks about it in the document 137 at 1.3. Then he further argues that permitting the limitations the government requested would undermine the presumption of innocence. Now, these arguments are unavailing, and the defendant did not identify a clear, particularized need to have Jane Doe number 5 name disclosed publicly. Now, the defendant knew who Jane Doe number 5 is and investigated her background, nor was there any need to disclose Jane Doe number 5's identity in order to impeach her. You didn't need to know her identity to even impeach her. It didn't matter. You say Jane Doe number 5, Jane. Okay? There was no need to disclose Jane Doe number 5's identity in order to impeach her. And then the defense counsel did a thorough cross-examination of Jane Doe number 5 about her prior statements without disclosing her name. Wow, what do you know? He was able to do it. Then finally, the court gave the jury an instruction that the use of nicknames or pseudonyms is common in cases that have garnered mention attention. And then it says, granted the application for witnesses to testify under their first names only, and explaining that the court will instruct the jury that this is due to the sensitive nature of the conduct the witnesses will describe and the likelihood of embarrassing publicity. So in sum, a balancing of the risk to the victim witnesses against the defendant's interest supported permitting the requested limitations. The victim witnesses testified about humiliating and explicit acts of abuse, some of which took place when they were minors. So, the only thing they were talking about was impeaching her. It doesn't matter. It does not matter. The only thing they were talking about was even if they wanted to, identity in order to impeach her. It didn't matter. That's what they were talking about. You people were bugging out talking about impeaching her statements and all these other things. You heard impeach, and y'all already thought it's ready to get her out the way. Didn't matter. At the end of the day, she did what she had to do. She testified the way she needed to. And that was the end of that, y'all. Okay. Wow. So that's what that was. What happened now? Oh, right. The battle. Yes, the battle. The battle. So what do you guys think of that? She did what she had to do, right? Auntie Anne said, she slammed her gavel down. She said, that's what it is, bro. Guys, do me a favor. Please don't forget. Hit that like button. If you are not subscribed, please subscribe to my channel. And if you would like to donate to the channel, you could donate through Cash App, PayPal, or Zelle. You can always go to the About section of my channel. If you can't see the information scrolling on the screen, I have my information on the About section in my channel. Okay? Thank you, guys. It's been real. It's been a minute. Thank you very much, sir. Mr. Okub, Reverend Febway. Would anyone, by any chance, before we get off, do the people would like to say something? Would the people like to say something? I'll drop my link in the chat. Y'all can come on the panel. You can say something. And then I'm going to close it out from here. We got, like, if anything, 15 more minutes. And then I'm closing shop. You're very welcome. You're very welcome, ladies. Y'all already know I love y'all too. And guys, don't forget to please join the membership so we can do the book reading. I'm going to start reading. I guess maybe I can do it Friday. Yeah, I'll do it tomorrow. We'll do it tomorrow. Tomorrow's Friday. I'll do it tomorrow. I'll set up a live. What would be the best time to do it for you guys who are members? Should I do it in the evening when everybody gets off work, right? Like after 6 p.m.? So it would be 6 p.m. Eastern time. Or maybe 9 p.m. for those on the west side would be 6 p.m. for them. Should I do that? Let me know. 6 p.m. tomorrow or 9 p.m. tomorrow. If I do it 9 p.m., at least the people on the West Coast can watch at 6 p.m. when they get off work. What y'all think? What y'all think? Let me know in the chat, guys. Let me know. 11 p.m. UK time. So that would be 1 a.m. UK time. Oh, wow. 9 would be, right. That would be 1 o'clock in the morning for you, Ruby. But at least, Ruby, you're a member, so you could watch the replay, baby. Reverend Fatboy, hello.
Yeah, you can hear me?
Yes.
Can you hear me clear now?
Yes.
Yes, ma'am. How you doing?
Hi, brother. What's going on? How are you? So, what
Oh,
do
I'm
you think
straight.
about Auntie and how she
Oh,
made her decisions?
Auntie Ann laid it down on him. Laid it down for him.
She sure
Everything
did.
pretty much you talked about went against everything they were saying that happened.
Right,
So
right.
I'm like, shit, everybody looking foolish.
So, enough with all the riff-raff and the bull crap, right? And let's just get it together, people on the other side, okay? And stop being so misinformative, okay? Because it's not good for the people. The people want to know the truth. And you people just do nothing but lie,
They
lie,
don't
and lie some more.
they don't care about the truth.
No, they really don't.
So
They just
like I
want
said,
a
it's
bunch
more
of
the
people.
Instagram. Well, I can't. I take that back. I take that back. A lot of them don't know, and a lot of them probably do want the truth. But
Yeah.
like I said, some of these people just you already know they spinning that shit to what they wanted to say and wanted to believe, and it's just to the point where it's like if the shit's in black and white and this come out today or whatever, and it's saying this, how can you refute this? What you gonna complain about? She was unfair or some shit. But otherwise, I'm like, dude, it says what it say.
Right,
Like,
exactly. It's all in black
it's
and
not even
white.
worth the argument. You can say
The
somebody
jury,
did this, and my bad. I say you can say
oh no,
somebody did this and they did that, but
the jury, made their decision. The judge did everything according to the book. She was even nice. Excuse me. She was even nice. She was even nice and took out things so that it wouldn't overkill him.
yeah, but they're not gonna acknowledge that. You know, they're gonna go and say, oh, she wasn't fair. She didn't do this. You know that's gonna go. Um, like I said, it's hopefully she write another. Little summary things, whatever she does. Hopefully she do another one or something.
Another what was it called? Another op-ed.
Hold on, my bad. I'm on the ride.
It's okay.
Yeah, right.
Another op-ed. Another opinion piece.
Right. Opinion piece. I'm sorry. But the
Yeah.
thing about it, they don't give a fuck about an opinion, which is crazy because, yeah, you had people there, but they actually was in the courtroom to hear audios and see visuals and, stuff like that. So when people want to go to credible sources and all of that, I'm like, the judge technically be the most credible source.
Plus, they had other evidence that they were just reserving.
Yeah,
The judge
I can't.
said there was things that was on reserve, like it was just sitting there waiting to be used.
Yeah, that's kind of.
And
You
they
know
didn't
what? That's why.
there was a
You know what?
preponderance there was a preponderance of evidence that they didn't even use all of the evidence because it was not necessary.
Wow. Well, I'm gonna say
She
this.
said it was overkill. She said it in this memo here, this order.
Wow.
It would have been an overkill, and she didn't want to overkill him. That's not fair. So she was
But
only
listen to me.
bringing things that were relevant to the case. Nothing more,
Right.
nothing less.
Well, hold on. Let me say this. Um, like I said, that's why, and I'm grateful for you because a lot
Thank
of these things I wouldn't know at all.
I love you too.
So I'm grateful for you, and you
Thank you, bro.
bring great information,
Thank you,
very
brother.
insightful. It's like I said, it's real. It's a real good informative live, and I
Thank you,
know
bro.
people in the chat can appreciate. You know what I'm saying? An informative live with truth, and you don't have to spin shit to make it say some things or spin it either way. You just tell it how it is and how the black and white say it,
That's
and
it.
you all
That's it.
appreciate
That's
it.
all. Thank you, bro. That's it. That's all I do over here, sir. You're right. I read black and white and comprehend it, break it down and comprehend it the best way I can on a comprehension level. I don't have no degrees. I'm not a lawyer. I'm just a normal person who wants to learn and knows how to learn. That's it. That's all. And I'm glad all of yous are here with me to
Yeah,
learn too.
but this the thing. Like even with, like I said, you got a couple. Like I said, you got lawyers in the sector. They bring it too, but they only can, they telling them what it is, and they just don't want to hear it. When people like put it like this, you get a lawyer and they breaking down the stuff to you, and you're still trying to spin it to something that is not, and they're telling you it's not that.
Right.
That I like I said, there's a lot of stuff I just look at and be like, man, look, why are we doing this shit? Not every fucking night. We shouldn't do this every night. It can't be the same shit every fucking day.
Right.
Because people fail to realize if it was that easy to get this nigga off, he would have been off. He got the resources.
That's right. Absolutely.
Like I said,
Absolutely.
nigga talking about he coming home 2022. I mean, before 2022. Shit, all right.
Where is this happening? This is not happening.
What the fuck going on? Like I said,
It's all a dream.
maybe he got insight or some shit, but you going live saying it. And my thing is, man, stop giving. Listen, you give them hope, but damn, you give them real false hope. Nigga, you worse than a preacher. You know what I'm saying? Like, come on, man. Like, damn, if it was that easy, like I said, you can feel how you want to feel. You can feel he not guilty. You can feel how you want to. But I'm just want to do. Don't come out here and lie to me, or don't come out here and try to spin some shit. You know what I'm saying? That's gonna be hard pressed. Because at the end of the day, you had a lawyer out here. She proved to you that one man can be an enterprise. How much more explaining do you need to know? You know what I'm saying?
Right.
Like, what the fuck is that? You may not like it, but nigga, it is what it is. Fight to change the laws and stop fucking bitching about it. Because guess what? At the end of the day, it is what it is. Like, nobody put him in this situation, but mostly himself. Now, the people around him do need to go to jail also.
Yes, I agree.
Like I said, it is what it is. And don't equate me with R. Kelly, because he don't speak. He's not he don't represent black men. Not the black men I hang around. If he represent the black man you hang around, then you need to stay around him. Don't be around me.
Right.
Stop equating.
Stop
equating all this shit to race and stuff, man. If that man did that shit, man, he wrong. He dead ass wrong.
It has nothing to do with black, white, old, young. It has to do with the person and the actions he took.
Right, but that's the thing. They, like I said, and I admit to you, in some cases, yeah, you can see race play a part in some cases. You see it, but this shit here, nigga, shit right here, nah, nigga, he was abusing black,
right,
younger females, black females. Nigga, we can't. Like I said, eventually you could condone it in people pissing on people and then you're gonna say he didn't do it. I'm like, okay, if you don't believe it, we can't force you to believe it. But most of the victims are women of color. That's all I'm saying.
Yeah.
So
exactly.
when you are, like I said, I can't sit here and say he never did nothing. He, like I said, even say he did it to one person, two people, he still did it. He still deserved to get that time for what he did.
Exactly.
He violated it.
Exactly.
So like I said, if people want to sit there and be like, oh, he couldn't, like, nah, bro, if he did it, he did it. Like I said, did they overcharge him? You can try to debate that, but otherwise, it's like, dude, he's at what he's supposed to be.
Right. There was a preponderance of evidence, no matter what, direct evidence and corroborating evidence that intertwined and made it to what it was, exactly what they charged him with. That's it. That's all.
Right, man. I'm like, and I just, like I said, I value the people in the sector who bring the real information and be real informative, instead of trying to, spit theories and stuff that you don't even know that really happened. Yeah. And like I said, I always respect y'all for it. And hey, have a good night. I'll hit you up later, man.
Yes, peace.
Have a good night.
All right, brother. Everyone, thank you for stopping by. Y'all already know. Don't forget to hit that like button on your way out. And I will be back tomorrow with some more goodies. We're going to read Jane Doe's number 9 book. We're going to start with chapter 9. Sunday, I have a treat for you guys. Dre from Public Announcement will be hanging out with us. He likes us over here on OCOB. He loves us, OCOB ladies. That's right. Don't get mad. Don't get mad. Don't get mad. Okay? Okay. And that will be on Sunday at 5 p.m. Eastern Standard Time. Okay. So hope to see you guys Sunday for that. Tomorrow, all my members, I will see you tomorrow to start reading the book with you guys. And if I have time, I will also try to do another live to talk about R. Kelly's 2008 trial, which is also part of his new federal trial for his 2008 obstruction of justice. So I just want to go back to his 2008 case, and that's what we're going to do. And we shall remember that over here, I like to keep my foot on R. Kelly's neck. That's it. That's all. I don't want to fight with nobody. I just want to keep my foot on R. Kelly's neck. That gets them mad. It's okay. I'm good with that. So, guys, I love you guys. And don't forget to leave your comments in the comment section of the video. Thank you, guys. Peace.